Who's there at the host portal?
Yes, ma'am, you're audible, ma'am. You're audible.
Yeah, but I need to share a PPT, and can I just give?
Yes, you have the rights, ma'am. Just have to click the share button at the bottom. There's a share button at the bottom, ma'am.
You have to give access to my email, which is Chambers of Vibha Makhija. My junior will do the PPT.
Okay, ma'am. Yes, ma'am. The presenter rights has given to Chambers of Vibha Makhija.
Yeah, we got it. Thank you.
Yeah.
Yeah, Mr. Hansaria.
Yeah. Good afternoon, Vibhaji.
Good afternoon.
Can everybody see me and hear me properly?
Yes, you're audible and visible, sir.
Very well. Okay. So we'll start at we're almost 4:15. So are all candidates joined, or are you expecting how many people to join, or because
300 people again.
so Mr. Walia, you are there, so you can tell us. We can start whenever you think that time has started.
Mr. Hansaria, I see about 312 participants.
Okay. Yeah. I think we can start, Ms. Makija.
I think so.
All right.
At least you can
Mr.
start
Walia,
with the
Mr. Walia, can we start?
Sir, good evening, sir. Myself, Harish and Deputy Registrar from AOR section. Sir, you may start, please.
Very well. Okay. Everybody else is muted. Ms. Makija and myself are only on unmute.
Yes, sir. Yes, sir. You can start, sir.
All right. So, good afternoon, everyone. So today we will be, first of all, let me wish you a very best for the exam, which is on 12th June, the paper 1. Advocate and record is a very important milestone in everybody's professional career, especially in Supreme Court. So today we will be discussing about practice and procedure, which is the paper 1. As per the syllabus, it has 2 parts: relevant constitutional provisions relating to the jurisdiction of the Supreme Court, and the Supreme Court rules relevant provisions of CPC, Limitation Act, and the Court Fees Act. Let me tell you first that you please understand the question paper properly. If you see the last few years question paper, there are 2 parts. One is subjective, one is objective. Try to answer the objective part first, and then you divide the time as to how much time you have for the subjective part. Because I would like you that you must answer all the 100 marks questions. Don't leave it anything. There is no negative marking, so there is no fear. And you must analyze Supreme Court judgments, which are jurisdictions, which are broadly speaking, which my colleague Ms. Makija will tell you by PowerPoint presentation, very nicely made. First is original jurisdiction, then we have appellate, then we have transfer jurisdiction, then we have advisory jurisdiction, then the Supreme Court has curative jurisdiction and contempt jurisdiction. Once Ms. Makija tells you broadly about this in a nutshell, please hear very carefully. Then after, I will try to explain in a little more detail, and then we will have a question answer session. Now, I think Ms. Makija, you can start. You can please start with which you shared with me, the PowerPoint presentation, very nicely made. So, Ms. Makija, please. I don't see her on the screen there. Okay.
Do you see me?
Yeah. Not.
Okay, I'll be somewhere up on the screen, one of the windows on the screen, but I'm just sharing the PPT. Uh, Welcome everyone, and please don't be scared. This is not an intimidating paper at all. And everyone having an experience of more than 5 years, of course, at the bar here, you probably have covered at least 50% of the paper during your practice time. So, what I am going to do for you in very rapidly and quickly is to first give you one, model method of answering your longer questions. And then I will walk you through what I can say is the syllabus of the paper. So you have only two textbooks, which are Constitution and Supreme Court rules. So these are the two textbooks you need for the entire paper. And essentially, what we are testing everyone at is whether you know the various jurisdictions which are available to the Supreme Court to exercise its powers. So Supreme Court acts in various capacities, and essentially there will be, as Mr. Hansaria said, an appellate jurisdiction, there'll be an original writ jurisdiction, there'll be a contempt jurisdiction, and then of course there are various appeals under specific statutes that are available. And last but not the least is also the original suit jurisdiction between government agencies. So I will dive into this straight away without wasting any time, because Mr. Hansaria has to tell you how to answer the rest of the paper. And I will just tell you, I will take one topic on which I will talk about what should be your skills when you're answering the paper. When you are answering a descriptive question, then it is essential that you know the provision under which the question is asked. Secondly, what are the contents of that provision? Thirdly, is a little understanding of the provision, which you can expand in your own way, or you can take the help of case law. So certain jurisdictions are very well defined by, locus classicus cases, which are classic cases in those particular jurisdictions. And it'll be of great use if you just have a look at that case, because that would explain to you in detail what the jurisdiction is. So if you see this first slide, take for example, if a question is asked that what is the special leave jurisdiction of the Supreme Court? So you have to first of all state under which provision is the special leave jurisdiction of the Supreme Court provided. So as we all know, it is Article 136. Then if you read Article 136, you will find the components, the manner in which that jurisdiction can be invoked by a petitioner, and how the court can exercise that jurisdiction. So you will then work out and write out as to in what situations you can invoke the jurisdiction. For example, the SLP can be filed against any judgment or decree, sentence or order of any High Court tribunal in the territory of India. Now, to just understand this a little more specifically, Article 136 can be invoked against any order whatsoever issued by any court of any jurisdiction within the territory of India. But the caveat comes as to the manner in which the court exercises its jurisdiction. So there are some self-imposed fetters which the court has imposed on itself while exercising this discretionary jurisdiction. So please be very careful about certain keywords. So for example, Article 136 is a discretionary jurisdiction, in contradiction to say something like an appellate jurisdiction or in distinction to something like an original jurisdiction. So this is a special jurisdiction which is discretionary in nature. So, for example, in criminal appeals, by and large, the courts will issue notice and put it for admission. But in SLPs, as we see every day in our experience, the discretion has to be exercised at the very first step itself to understand whether the court will exercise that jurisdiction or not. The exception to exercise of SLPs by the Supreme Court is that when it is with respect to any judgment arising from a court or tribunal constituted by by law relating to armed forces. So armed forces have been excluded from the jurisdiction of 136 because that's a special jurisdiction which is provided otherwise. So this is the first part of the answer. The next part of the answer is what are the special features of Article 136? So as I explained to you, it's discretionary. It can be filed against any order, but court exercises restraint from exercising the jurisdiction expansively. And then another thing that the courts have brought in by their own self-imposed, this thing, discretion, is that normally in interim orders, when matters come in SLPs against interim orders, usually the court doesn't exercise its SLP jurisdiction and then normally would encourage you to take your matter to the final stage and then come to the Supreme Court. Now, the leading cases on this I have given over here, and I will share this with the Office of the AOR Examination Office. And they will share this PPT with you so that you don't have to write down everything, but you'll have it handy. So, amongst the leading cases is that of Pritam Singh, Dakeshwari, and Kunya Mohammed. Now, Kunya Mohammed is a very important case for everyone to look into, and I would encourage all of you to read it as well, because here there is a discussion on how the jurisdiction has to be exercised. And then also subsequently, can that once an SLP is dismissed, can that jurisdiction be invoked yet again? And one of the very important principles that are set out in Kunya Mohammed is the distinction between dismissal in limine and dismissal on merits and the consequences of that. So if there is a dismissal in limine without any expression of the merits of the matter, then if an appeal comes to the court can look into the merits of the matter. Then now let us talk about other jurisdictions of the court. So this was with regard to how you would formulate your answer. Coming to what are the various jurisdictions of the Supreme Court, the first jurisdiction is the exclusive original jurisdiction of the Supreme Court. Now, these are suits under Article 131, and the thumb rule is that no party except the state can file an original suit in the Supreme Court. So, by and large, this is a kind of an exclusive jurisdiction which has been carved out. And the only parties who can approach the court in an original suit jurisdiction are the states or the center. So whenever there is a dispute between one state and another state, or a state and the center, or multiple states against the center, so these original suits for declaration, etc., can come directly to the Supreme Court. So this is a very restricted jurisdiction, and you might be aware recently the case of lotteries in Supreme Court is going on, in Sikkim lotteries, where the state has a dispute with the center with regard to the restrictions that are placed on the state with regard to the lottery procedure. So these are very few cases which come up in the history of Supreme Court, and it's a very restricted jurisdiction. So the locus classicus in this is the state of West Bengal versus Union of India. And this was with regard to the acquisition of coal fields which were used by the state. So there's normally a dispute with regard to what is the field in which the state or the union can operate. So this is one kind of a jurisdiction. The next jurisdiction is original, again an original jurisdiction, is Article 32. Now, Article 32, everyone knows very well. It is the right to approach the court with regard to a writ jurisdiction. Now, Article 32, everyone will already know. And in a way, this is a famous saying of Dr. Ambedkar, that Article 32 itself is a fundamental right. Because if you were given a fundamental right under, say, Article 19 or 21 or 25, etc., but you did not have the remedy to enforce it, then the content of those fundamental rights would become odious. So, to enforce your fundamental rights, you are given a fundamental right to enforce those rights. So, it is not procedural. This is a substantive provision on its own. And this is, as it is written over here, the heart and soul of the Indian Constitution. And the purpose of this article is to safeguard the entire spirit of the Constitution, which is to ensure that all citizens are guaranteed their fundamental freedoms and there is no violation of those fundamental freedoms by any agency of the state. So, like the old maxim has been quoted over here, that when there is a right, there should be a remedy also existing with regard to the right. Otherwise, the right is only a namesake right and really does not translate into anything substantial. Now, the leading case in this area is Bandhua Mukti Morcha, where the right, which also deals with the locus in a PIL matter, as well as how the right can be enforced in the Supreme Court. So it's a very good exposition on. Am I audible? It's a very good exposition on what is the content of Article 32. Now, essentially, every party whose right has been violated is the party who has the locus to move to the court for a remedy. Correct? But here is an extraordinary addition. I won't say exception. This is an extraordinary addition which has been made by our judicial activism, where public interest litigation, the locus of a litigant, has been recognized with respect to areas where public interest are involved. So suppose I don't suffer damage myself or my right itself is not violated, then somebody else who is more empowered can sue for the purpose of enforcing your right. So Bandhua Mukti Morcha was one of those bonded labor cases where somebody else moved the Supreme Court for the purpose of enforcement of the rights of bonded laborers. Now, this jurisdiction, according to me, is unique in India. This jurisdiction does not exist in America. Mostly we have imported our constitutional values from America and also from common law. And we normally think of the American courts as extremely protective about people's rights. But I must add over here that public interest litigation is what has made the Indian judicial system stand apart from any other judicial system world over. And this is an era which was heralded by Justice P. N. Bhagwati, where he he recognized the socio-economic condition of our citizens and said that until and unless this activism is not taken, the fundamental rights cannot be effected in their real spirit, so as to speak. So this is a very, very important jurisdiction. And in conjunction with this, you will also have your Supreme Court rules, which give the parameters of a public interest litigant. So we will go to that a little later. But please remember that public interest litigation is substantive, and the procedural part of it with regard to how you can approach the Supreme Court is a part of the Supreme Court rules. Now, as far as judicial review is concerned, judicial review is the strongest component of the basic structure of the Constitution. So while we may consider, while all the different opinions of Keshwanand Bharti have defined different parameters as part of basic features of our Constitution, the constant basic feature of our Constitution is judicial review. So the principle to remember here is that no law whatsoever can exclude the power of judicial review of constitutional courts. Kindly remember the distinction. Jurisdiction may be excluded from, say, civil courts, maybe from tribunals, maybe from appellate jurisdictions or special statutes. But as far as the writ courts are concerned, the High Court under Article 226 and the Supreme Court under Article 32 will always have the jurisdiction to judicially review any action, although there might be again a self-imposed restraint when there is an alternate remedy that is available. So if there is an alternate and efficacious remedy that is available in law, then the courts, original courts, may not exercise their power to judicially review the action. Now, as you can see on the slide, Keshwanand Bharti, of course, is the iconic case. Then State of West Bengal versus CPDR is another very important case there, where again they reiterated that judicial review itself is a part of the basic structure of the Constitution and cannot be ousted even by a constitutional amendment. So this has taken it to a next level and said that not only can you not make any law which can abrogate the power of judicial review, but you cannot even amend the Constitution to such an extent that it excludes the power of judicial review. The same principle has again been reiterated in the National Tax Tribunal case, which was with regard to the members and constitution of the National Tax Tribunal and the nature of it. And here again, the principle has been reiterated. Am I audible to all? Because I can see some messages. Can someone raise their hands if I'm audible? I can see Vinay Sharma on my screen. Okay. Just a minute. I think some people. Okay, audible. All right. Now there are some situations where judicial review can be excluded, and those are basic immunities which are granted under the Constitution. So first, of course, is the privileges and immunities of members of Parliament. So essentially, because of separation of powers, the powers of the Speaker are supposed to be immune from a judicial review. However, we have seen that this law has now developed, and those powers also are brought under under the umbrella of judicial review if the courts find that there is a substantive violation. If there is a procedural violations, the courts will again not go into a review of those actions. However, if there is a substantial constitutional violation, then the court's power is again not excluded. Similarly, the power to grant pardon, suspension, remission, and commutation of sentences vested in President or even the Governor is also excluded. The other thing is that although we have seen a little more of this happening, say in Vishaka case, etc., the power of the courts, there is a self-defined Lakshman Rekha that the courts follow, which is to not exercise its power in a way to give a mandamus to the legislature to enact something in particular. So that is again something that the courts will exclude from review. Now let us come to the appellate jurisdiction. In appellate jurisdiction, we have three kinds of appellate jurisdictions. First is with regard to appeals which involve interpretation of the Constitution arising out of any proceedings in a high court, civil, criminal, or otherwise. So whenever an interpretation of Constitution is involved in a particular matter, an appeal can be filed against that. Article 133 is with regard to civil appeals, but in 133, 134, normally the high courts give you certificate to appeal. So whenever a high court passes an order but thinks that it is an issue which should be adjudged by the Supreme Court, they issue a certificate of appeal. These practices have now become a little redundant in view of expansive use of 136. However, there are some cases where this power is exercised by the high courts and certificates are issued and the appeals come straight to Supreme Court. Next. Now we come to statutory appeals. With this tribunal Raj, where we have several tribunals which have come up, we have appeals coming to Supreme Court under those specific enactments. So, for example, there is IBC, or there would be certain appeals provided under the Customs and Excise Act, then under the Consumer Protection Act. Now, under these specific statutes, there are statutory powers given to the Supreme Court of appeals against the final orders of the lower court. So the final appeal, you can say almost say a second appeal, finally lies with the Supreme Court. But please remember that these are provided by statute. And these are specific enactments which provide for this purpose. If an enactment does not provide for a statutory appeal to Supreme Court, then that jurisdiction is not available to Supreme Court and a litigant will probably have to come under Article 136. So Section 379 of CRPC provides an appeal to the Supreme Court against an order of a sentence, of a conviction and sentence. So normally when we argue criminal matters and there has been a concurrent conviction and sentencing, we file a criminal appeal. And normally we tell the judges that this is an appeal and therefore this is not like an SLP and notice must be issued and the appeal must be converted into, should be admitted and heard in total this thing. Then we come to Section 130E of the Customs Act. Again, this is a statutory appeal. You'll go through these provisions and you will see the limited jurisdiction of these appeals. So these appeals under the Customs and Excise Acts, in some cases, appeals are provided for. In many cases, appeals are not provided for. So for example, if there is a classification dispute, then it will be appealable. However, if it is a recovery dispute, then it may not be available. So you'll probably be required to check up Section 130E and see what exactly is the position under which you can file an appeal. Then, of course, is Section 23 of the Consumer Protection Act, then Contempt of Courts Act, SEBI Act, TRI Act. Next. So under these statutes, you will probably have more statutes also, but these are the primary statutes. Then comes the review jurisdiction, which is under Article 137. Now, review jurisdiction, you know the thumb rule, that it can be only in cases when there is an error manifest on the face of the record, number one, or something new has come which could not be put before the courts. So, review jurisdiction is again very limited. And the second limb of review jurisdiction is the Supreme Court rules, which provide for the procedure as to how review petitions have to be heard. So, in civil cases as well as in criminal cases, review petitions are heard in chambers. They are not heard in open court. You may have to file an application for an oral hearing. However, after Mohammed Arif case, now review petitions against confirmation of death sentence are compulsorily heard in open court, constituting of at least 3 members bench. So that's one digression from the normal thumb rule of hearing review petitions in chamber. So you'll do well to look at the Supreme Court rules hand in hand with the substantive aspect of the review petitions. Then comes the curative petition. Now, curative petition is a device which you will not find in the text of the Constitution. This has been incorporated later in the Ashok Hurra case, where the court found, where the Supreme Court found that there was manifest injustice on the ground of failure of natural justice. So what had happened over there is that the party had no notice whatsoever that the matter was going on in Supreme Court and comes to know of it much later. So certain exceptions were provided and a very strict regime has been provided under the curative petition, under the judgment of Ashok Hurra, Rupa Ashok Hurra versus Ashok Hurra. And you will see the last 2 paragraphs where they say when the curative petition can be invoked and the procedure by which you can invoke the curative petition. So the curative petition can be invoked only on 2 grounds. When you find that the judge had some specific interest in the matter and therefore there is a severe allegation of bias. And second was when there is a complete failure of natural justice in as much as the party had no notice of the proceedings ongoing in the court. Only in these 2 exceptional circumstances, and the method and the procedure has also been made very stringent. So it needs to be certified by a senior counsel whether the grounds are made out, because this is a jurisdiction which has been created by the Supreme Court itself to correct manifest injustice which can occur. And you can see in the last paragraph the procedure under which the curative petition can be filed. Then comes a contempt petition under Article 129. Now, this is a constitutional power which is given under the Constitution and is independent of the power which is given to the High Courts under the Contempt of Courts Act. And Contempt of Courts Act cannot restrict the power of the Supreme Court under Article 129. And under Article 129, the Supreme Court can also take suo moto cognizance of certain proceedings and convert them into contempt proceedings. So the procedure which is provided under the Contempt of Courts Act is that you have to take the consent of the Attorney General or the Solicitor General. However, when the court takes suo moto notice of contempt proceedings, then this procedure does not require to be followed. Types of contempt, I'm sure all of you are aware, are civil contempt and criminal contempt. And in civil contempt, the thumb rule is with regard to willful disobedience, whereas criminal contempt is with regard to abuse of process of court. So this is the basic thumb rule, but of course the rest of the components you can read and work out for yourself. Then comes the jurisdiction under Article 141. This again is a very important jurisdiction. Besides the contempt jurisdiction, the jurisdiction under Article 141 is an extremely important jurisdiction, because what it does is that any judgment that is passed by the Supreme Court is the law declared. So it takes up a legislative flavor. So here it's very important to understand that under 141, the Supreme Court is not acting only in a judicial capacity, but it also has the trappings of a legislative capacity. So any interpretation of law which is done by Supreme Court is declared as law, which is enforceable in the entire territory of India. And uh, and the thing is that all courts, not just the parties, of course, the parties are required to follow the decisions, but all courts are also required to follow the decision. So, for example, if the High Court thinks that that say, for example, the High Court has a difference of opinion on, say, Ashok Hurra case. It says that this is not provided by Constitution, and going by the language of the Constitution, this is something that is extra constitutional. So I cannot hold this. I cannot apply this case in my judgment. However, the High Court is bound by Ashok Hurra till such time that it is either distinguished or set aside by the Supreme Court. So the High Courts may have a different view on various issues, but those views have to be following the Supreme Court view, which is the law declared by the for the entire territory. Then there is an advisory jurisdiction. This advisory jurisdiction is invocable by the President to consult the Supreme Court on certain contentious constitutional issues. So, when you see the judgments which say in re Delhi laws or in re whatever, then an advice is sought by the President as to what would be the interpretation of this particular constitutional provision or a statutory provision. So the article authorizes the President to refer this question of law of fact of public importance to Supreme Court and obtain its opinion. And that power is then is also coupled with the power of Article 131, where the President can refer a dispute also to the Supreme Court. Now, Article 143, the important part to remember is that Article 143 is not a jurisdiction available to the Supreme Court, but it is a power which the President invokes. So if you get the nuance of the distinction between the two, so that's the fine distinction between the manner in which Article 143 is to be invoked. Now, the special reference by President is also there under Article 143. Now, the references made under Article 143 are not the law declared by Supreme Court under 141 of the Constitution. So, it is not binding on inferior courts, even though it has high persuasive value. Even if the opinion given in the exercise of advisory jurisdiction under it may not be binding, but is entitled to great weight. So, you've understood the distinction. Advisory jurisdiction, as its name suggests, is only an advice given to the President. But that advice is weighed by reason, by law, and also by the experience of the judges. So, by and large, the presumption is that this advice is sound advice and is legal, and thus it has very high persuasive value for all courts. So if a dispute comes to a particular court, it can, which has never come to it before, it can rely on the advice and say that this reasoning is what appeals to me. So the two major cases under this is the natural resource allocation case and the Kaveri Water Disputes Tribunal case. Then transfer jurisdiction, I'm sure you all are very well aware, there's civil and there's criminal. So I will not spend any time on that, but that is one jurisdiction of the court. And then, of course, there's 139A. So I'm not going to spend any time on transfer petitions, which you can look at yourself. This is an overview of the Supreme Court rules in front of you. So essentially, you have to see that Supreme Court rules are enacted under Article 145. So the Supreme Court has the powers to regulate its own procedure. And 2013 rules completely revamped the previous rules. So the previous rules were not as detailed as these rules are. Under Chief Justice Lodha, there was a complete revamping of the existing rules, and now we have a more logical set of rules. Now, Order 4 is in relation to advocates, their registration, and their conduct. Let me just open it myself. And Supreme Court rules are something which I will encourage you to go to time, because a lot of times, especially when you're a regularly filing advocate, there are sometimes you run into some walls where you don't have an answer. You'll usually find that answer in the Supreme Court rules. So essentially, it gives the parameters of the persons who can file. So AORs can file wakalatnamas, senior advocates cannot file wakalatnamas. Then it gives, this is most important, you people are all appearing under Order 4, in which manner you can register as AORs and how you will finally get the certificate, and whether you have to have an office. So all those parameters are given in this, and I'm sure you all would have gone through. Then Order 5 is with regard to, now these are a little tricky ones. Now Order 5 deals with business in chambers. So which are the matters? Single judge, chamber judge, these are the different jurisdictions and the registrar. So please look at this very carefully, and I would suggest that you mug up which matters will be listed before the chamber judge and which matters will be listed before the registrar. So you kindly look at Order 5, which says that which are the applications. Just mug this up, find whichever methodology. Yeah, just see this method. These are all listed out over here. Make your acronyms or whatever, and learn up which ones will be listed before the chambers. And then what is the power of the chamber judge? So subclause 1 relates to the registrar and subclause 2 relates to single judge. Then you come to Order 6, which is the constitution of division courts and powers of a single judge. Now, in addition to the powers of business in chambers, a single judge also has various other powers, including a vacation judge. So, under Order 6, Order 6, Rule 6, you will find the powers of vacation judge, which the matters that he can entertain singly. Then you have, I have marked out the specific ones which are used more by us. So these are probably the orders you should pay more attention to. Not to say not to look at the others, but these are the more important ones. Then you have Order 11 with regard to notice of motions. Then with regard to appellate jurisdiction, Order 19 provides how civil appeals have to be filed and what is the procedure of filing the civil appeals. Then you have Order 20 with regard to criminal appeals, then SLPs, then under special acts, then you come to original jurisdictions. And I would suggest that you look at Order 38 specifically, which is, I think, one of the favorite questions for the paper setters. So just pay more attention to Order 38. And the rest of them, again, are something that you want to look at. So I will now hand over to Mr. Hansaria, who will now give you an overview of the papers, and then we will open the floor for questions. I'm going on mute now. Mr. Hansaria, over to you.
Yes. Can everybody hear me? Very well. Okay. My colleague, Ms. Makhija, has covered the entire course and syllabus, so there is little for me to add, but then let me try to be concise and put you specifically on point wise. See, first is this original jurisdiction of the Supreme Court. Please make a note wherever you can. The original jurisdiction has three parts in the Supreme Court. One is suit under Article 131. Suit is between the Union of India and the states, between the states and the states, or Union of India, the states as one and the states other. Please make a very note, there cannot be any private party involved in a suit under 131. And please make a note of the relevant rules along with it. Rules 25 to 20, Order 25 to 27 of the Supreme Court rules deals with the original suit. The original suits are filed very less, but it's very important to know that the original suit is between the government and no private person, and it is mark the expression which is used in 131, on which the existence or extent of a legal right depends. Please analyze with certain case laws, what do you mean by existence or extent of legal right? Now, Supreme Court has said in certain cases that the states can challenge under 131 validity of a law made by the parliament or otherwise. So that is also very important to know. Suppose the state want to challenge, and it has happened that the state has challenged, state of West Bengal has challenged the Coal Acquisition Bearing Act. There the question was whether it can be entertained. The Supreme Court did say it can be entertained. So original jurisdiction is regarding suit under 131. Second original jurisdiction is under Article 32. My friend Ms. Makhija has told you. But what is important to note in under Article 32? It is for enforcement of fundamental rights. You can you can approach the Supreme Court only and only when you are alleging violation of fundamental rights. Unlike in Article 226, you can approach the High Court for any other legal right. So this distinction is to be noted by all of you very carefully. Supreme Court, though it's a higher pedestal, is an appellate court, but their jurisdiction, original jurisdiction, writ jurisdiction is limited to enforcement of fundamental right. High Court jurisdiction is wider to enforce any other legal right, means not a contractual right, but a right flowing from some statutes, can also be enforced under Article 226 of the Constitution. And as my friend has said that, yes, it is a fundamental right under Article Part 3 of the Constitution. And also, what are the writs, what are the orders which are passed? Article 32 say you can, so Supreme Court can pass orders, issues, directions, orders or writs, including, this is inclusive, habeas corpus, mandamus, prohibition, quo warranto, certiorari. These are the 5 writs which are known. Please carefully know what are the nature of writs which the Supreme Court issues. These are the 5 writs which the Supreme Court issues. You must be aware of it. What are these rights? What are these writs for? Who can invoke and for what purpose it can be invoked? Thirdly, an Order 38 rules with Article 32 petitions. Make a note along with your Article 131. You have Order 25 to 27 of the Supreme Court rules. Under Article 32 petition, you have Order 38 of the Supreme Court rules. Now, third original jurisdiction, which we miss out many a times, it's regarding the election disputes of president and vice president, which is, and this is very broad, not only election petitions. Article 71, which is the original jurisdiction of the Supreme Court, is all doubts and disputes arising out of in connection with the election of the president and vice president are inquired into and decided by the Supreme Court. And you cannot challenge in any other court. So if there is a dispute about, say, voter list, about the election results, about the nomination papers, the original jurisdiction of the Supreme Court is under Article 71 of the Supreme Court. You can approach only the Supreme Court, not any other court. And here also, Order 46 of the Supreme Court rules govern this procedure. So you have three original jurisdiction: suits under 131, writs under 32, and presidential election or vice presidential election dispute under Article 71. So these are the three broad original jurisdiction of the Supreme Court. Now, I come to, because the time is, I think, another 15-20 minutes. Mr. Walia, how much we can go in? Or we can go up to, I think, we'll give some time for question and answer. Anyway, I'll go further. Next is, so I have the original jurisdiction, my colleague has told you, and these are the basically three components of original jurisdiction. Please keep in mind. Second is the appellate jurisdiction. Please note, appellate jurisdiction are again twofold or threefold, I will say. One is appeal under Articles 132 to 134. Put it in one bracket. As to the interpretation of the Constitution or substantial question of law generally public importance, and where the in criminal cases, High Court has reversed an acquittal and convicted for a death sentence. Under three cases, you can come to Supreme Court as a matter of appeal under Article 132, 133, and 134. But 134A, you have to come via certificate by the High Court. As Vibha has said that most of the time, nobody now goes for certificate. There is a jurisdiction. You must be aware of it. Then comes the SLP, SLP jurisdiction 136. 90% of the cases are filed under the SLP. My colleague has gone very detailed in the SLP jurisdiction. I don't want to repeat that. Only thing is that please make a note that while filing an SLP, what all you need to do. You have to give a certificate, what certificate you need to do. While filing an appeal in the criminal case, you have to give a surrender certificate. What is the surrender certificate you should do? What are the prerequisites of filing an SLP? Civil SLP and criminal SLP, you must be very aware of it. Second or third limb of appellate jurisdiction are under various statutes. The list of statutes have been given to you. But what is important is, make a note, under what circumstances you can approach the Supreme Court. For example, under the Advocates Act, you can approach the Supreme Court against any order of the Disciplinary Committee of the Bar Council of India, appellate or original, against any order. So if a Bar Council of India in a disciplinary proceedings passed a final order, you can appeal to the Supreme Court. Under the Consumer Protection Act, you can appeal against an original order of the NCDRC. Under the Representations of People Act, against any final order of the High Court in an election petition. Under the Electricity Act, on a substantial question of law. Under the National Green Tribunal Act, against any order or decision of the NGT. Against the Telecom Act, TDSAT, you can come on a substantial question of law. Why I'm saying all this is, make a list of the appeals under which the statutes are there, which are available in the Supreme Court rules or in the relevant statutes. There are 9 or 10 statutes which are there. You can make a hurried note of it. 1, Advocates Act. 2, Consumer Protection Act. 3, Representation of People's Act. 4, Electricity Act. 5, National Green Tribunal Act. 6, Telecom Authority Act. 7, Contempt of Court Act. 8, SEBI Act. 9, Customs Act. But what is important for you to note is, in certain cases, Just like NGT, you can come against any order of NGT, even interim order, against final order, or any order. Very important for you to know. In some cases, you come against the final order. For example, in the Representation of People's Act, when the High Court finally decides the appellate, the election petition, you come as an appeal, not as an SLP. In some cases, you come against the questions of law. For example, under the SEBI Act, Section 15Z says on any question of law, you can come to the Supreme Court. And in some cases, just like Electricity Act, Telecom Regulatory Act, you come against the substantial question of law, similar to Section 100 CPC. So 4 nature of appeals are there. One, against any order, interim or final, NGT. Against final order, like Representation of People's Act. Against questions of law, SEBI Act. Substantial questions of law, Electricity Act and Telecom Regulatory Act. Make a note, it will be helpful for you. Then in criminal cases, apart from SLP, see, in under 134 of the Constitution, if the High Court on appeal has reversed, please make a note. Under Article 134 of the Constitution, an appeal lies to the Supreme Court if and only if the High Court on an appeal has reversed an acquittal order, convicted and death sentence. You appeal to the Supreme Court. Or the High Court has withdrawn the trial to itself, conducted a trial and convicted a person to death sentence, appeal to the Supreme Court under 134. But under 379 CRPC and Criminal Laws Enlargement Jurisdiction Act, if the High Court in an appeal converted the conviction or reversed the conviction, reversed the acquittal and convicted you, the person, for imprisonment for life or 10 years imprisonment, appeal lies to the Supreme Court, Enlargement of Jurisdiction Act. And also under the Enlargement of Jurisdiction Act, if the High Court has withdrawn the trial to itself and convicted a person to life imprisonment or 10 years or more. So there are 3 sets of things in a civil criminal appeal. One, death sentence cases reversed by the Supreme the High Court. If there is a concurrent finding of trial court and the High Court, appeal does not lie. What lies is an SLP. Sorry. Similarly, if the High Court reverse an acquittal and convicts you for 10 years or more, then appeal lies, not an SLP. In other cases, appeal will lie. You have to give me a break for 2 minutes. Just a minute. Very well. The third thing is transfer jurisdiction. Transfer jurisdiction is also in the 2 things. One is constitutional power of transfer. Another is statutory power of transfer. Constitutional power of transfer is 139 capital A, in which the Supreme Court cannot transfer it just like that. There are 3 requirements under 139A. Please read it very carefully. It must involve the same or substantially same the question of law. The question must be pending in 2 or more high courts, or in the High Court or in the Supreme Court. In such cases, so 3 things involve the same or substantially the same question of law. There must be question of law. Pending in 2 or more high courts, or pending in 1 or more high courts and Supreme Court. Supreme Court can transfer it to itself or transfer it from one high court to another and ask the other high court to put a hold and then decide. So this is the constitutional power of transfer. Statutory power of transfer is Section 25 CPC and Section 406 of CRPC, which is again very wide. It says expedient in the interest of justice. Very wide power, and the Supreme Court has been exercising, especially in matrimonial cases, expedient in the interest of justice, no other restriction. Constitutional power, there is a big restriction under 139A. But so far as the statutory power of transfers 25 CPC and 406 CPC, it only says for the expedient for the end of justice. Supreme Court feels expedient in the interest of justice or ends of justice. It can transfer from one court to another court in one state to another state, either from the High Court to another High Court or from a lower court to another lower court. But please make a note here also. There are certain High Courts in the country where Punjab and Haryana, Guwahati High Court, where it has jurisdiction over more than one state. For example, Punjab and Haryana has jurisdiction from, in Punjab and Haryana, Guwahati High Court jurisdiction over 4 states, Assam, Nagaland, Mizoram and Arunachal Pradesh. What happens between transfer petition from, say, Haryana to Punjab? You don't come to Supreme Court. You have to go to High Court. Similarly, if you have to transfer from, say, Assam to Nagaland, you have to go to High Court and not to the Supreme Court. So this is an important thing you must know. Fourth jurisdiction is advisory jurisdiction. Again, advisory, as Ms. Makhija has told you, it is the Precedent which seeks advice from the Supreme Court. Please read the text of the provisions very carefully. Text of the provisions, the Supreme Court rules, and some of the case law, leading case laws. Then also you will be able to conceptualize and answer the questions which are framed. Advisory jurisdiction is on a question of law and fact. Again, it's advice. The Supreme Court can seek advice on law or on facts or both. And then normally the Supreme Court answers the advice, opinion or seeking. But sometimes it has happened that the Supreme Court says, no, it doesn't involve any question of law. It does not involve any dispute of fact. We're not advising. Again, as Makhija has said, this is an opinion of the Supreme Court, require great value, but it is not binding law under 141 of the Supreme Court. The fifth jurisdiction is curative jurisdiction, innovated by the Supreme Court in Ashok Hura. Now, you must also see wherever you are discussing the appellate jurisdiction, original, what are your views? It's very important to express your views. You all have a 5-year experience on the bar, which is 4 years experience and 1 year training. So you are here in the Supreme Court at least for 1 year and in the bar for 5 years. As an examiner would be looking, what is your opinion on the subject? One of the parties said, what is the fifth? Fifth would be the curative jurisdiction. Ashok Hura judgment, which is bodily lifted in the Supreme Court rules under Order 48 of the Supreme Court rules. There are certain prerequisites for curative jurisdiction. The grounds are mentioned. Again, they are not the only grounds. The Supreme Court Hura has said there are 2 grounds. Ms. Makhija has said that party is not heard or the judge is biased. But there are also, these are in what the Supreme Court has said, it is inclusive like this, but they are not that they are the only ones. And that is what the Supreme Court rules, Order 48 has specifically included in the Supreme Court rules, that the curative petition in terms of judgment of Ashok Hura, I don't find anywhere else, because Ashok Hura is a jurisdiction created. You can also express whether this jurisdiction should be there, should not be there, from where it is there. It is derived from Article 32. Article 30, because this is a jurisdiction over a judgment of the Supreme Court, passed in review. So by the time Supreme Court is, this is a 4th court or 3rd court, then there is a review, and this is almost a 5th court like. And who hears the curative? The senior judges. You must also apply your mind whether the senior judges have a more power than the junior judges. So all these are debatable things. And the more you express your views, the more the examiner will think that you know the subject, you express yourself. Don't just go by the language. Supreme Court, we always tell the judges, this is how it should be. So your views on particular issues should always be expressed in anything. One more thing which you must know is reference to larger bench. When a 2-judge bench does not agree, can it say, all right, refer to 9 judges? It was happening. But the Supreme Court in Pradeep Chandra Parucha, the 2002 judgment, Justice Bharucha judgment says, 2 judges cannot say 9 judges wrong. It can say only refer to larger bench. It will go to 3, then it will go to 5, then it may 7, then 9, and so on and so forth. Otherwise, it becomes impossible to, because 2 judges says 9 judges, Keswanan Bharti is bad. Let it be referred to. Now we have 34 judges. Let it be referred to 15 judges, 17 judges. This cannot happen. So that is what happened in one case, that 2 judges said refer to 7 judges because 5 judges is wrong. That cannot be done because 2 judges has to obey the discipline, and that is where the reference of larger bench, to what extent it can be made, that is very important for you to know. I don't want to go to the contempt jurisdiction, which has been explained by my colleague, but there are certain important principles which you must know while cases are decided by the Supreme Court. For example, what are the writs which are issued under Article 32 to 26? What are the difference between Article 32 to 26? What do you mean by per incurium, per curiam? Whether you refer it when it is per incurium or you decide yourself. You means the 2 judges can say 3 judges per incurium and decide, no, this is not there. Or 2 judges. So these concepts of writ, nature of writ, per incurium, what is the difference between obiter dicta and ratio decidendi? It must be known. What do you mean by precedence stare decisis? There are certain jurisprudential principles which a candidate is supposed to know when you are practicing the practicing procedure of the Supreme Court. And all this you will read some judgments on the specific jurisdictions of the Supreme Court. As my colleague has said, the basic books are Constitution, then the Supreme Court rules, and you will get some 1 or 2 commentaries also. And I would say that all of these commentaries will make it further clear because it contains the substantive provision, the rules, and the case laws. I think we should give some time for the anyone has any question. I would love to answer that, and then I will wish all the best because more than 1 hour has passed. I will be answering few questions, whichever is there. My colleague is there, I am there. So whomsoever you want, we will answer your queries, whatever is there, and then wish you all the best.
The question I
Hello, all the participants are requested to check the check box. Chat box.
Chat box. We have so many questions. We can go one by one.
Right.
Only opinion is required, or before that we will have to write down the concept also.
You want to take that, Vijay?
I think we should. There are a lot of. I think we will stop there. Or Vibhaji, you can answer one of the questions. Then we can answer. Or the first question is: comes to an appellate jurisdiction. Do we need mention SLP jurisdiction under 1T beyond or a part of the appellate? See, 136 is definitely an appellate jurisdiction, but it is a discretionary jurisdiction. You have to seek appeal to the Supreme Court, leave to appeal. You don't just file an appeal. So we don't call it an appeal. We don't file an appeal. We seek leave to appeal. Once the leave is granted, then it becomes an appeal. So it is in the realm of appellate jurisdiction because what is appeal? Challenge a lower court jurisdiction in a higher forum, maybe high court, maybe tribunal, maybe even the lowest court. As Ms. Makija said, that the jurisdiction of 136 is very wide against any order of any court. So that is the distinction. One of the candidates asked me what is whether 136 is an appellate jurisdiction. Yes, it will be an appellate jurisdiction in different format. One is 132 to 134. One is 136. Another is statutory appeals. Another question I find is that appeal under Section 23 of the Consumer Protection Act. Yes, it is a Consumer Protection Act appeal, and here you find you can file first appeal on any questions. It is not restricted that you have a question of law, you have a substantial question of law. Supreme Court may entertain or may not entertain, but appeal lies against any order of original order of the NCDRC, not an appellate order, because NCDRC acquires both appellate order and the original. If it is more than 1 crore, it is an original jurisdiction. Against that, an appeal lies to the Supreme Court under Section 23 of the Consumer Protection Act.
Mr. Ansari, I see one question which says, how are marks to be distributed amongst questions 5, 10 or 20? I think you can give them a little bit.
Now, you will, what I found is last couple of years, the marks are very, very clearly given in the question papers. There are objective questions which are smaller marks or lesser marks, and there are subjective questions which carry larger marks. That's why in the beginning I said, please read the question paper very carefully, divide your time, and objective questions, either you get full marks or you don't get marks. Subjective questions, it depends on what is your input is. So there, try, according to me, my advice would be first answer the objective questions which you know, then you divide your time for the remaining subjective questions. How many questions are there, how many marks each questions are carrying, based on that you have to answer. But please answer the 100 marks. That will be my advice. Yes, it includes both objective and because paper includes both objective and subjective. So you have to see the question paper carefully and then answer. Yes, one question is court fee payable under different filings. Yes, because your curriculum clearly indicate the Court Fees Act or the Supreme Court rules. So you must know what is the court fee payable for an SLP, for a civil SLP, for a criminal SLP, for a transfer petition, for an application, for writ jurisdiction. You are supposed to know, or even for a suit, you are supposed to know how much court fee is payable. Well, one question is saying that AOR examination evaluation, that is very difficult question for even us to answer. Brief idea about the evaluation.
So another thing that can be very helpful is Mr. Venkataramani's book, which is very exhaustive on the case law. So all the questions that I'm seeing on the screen over here, also someone has asked what is the best book or commentary. I think Mr. Venkataramani's
I
book
also
is
agree that this is, I also have prepared my lecture based on reading this. This is Mr. Venkataramani books is perhaps the only book which I can, last 2 days I've been reading this only. Because you read the act, read the rules, and then the Mr. Venkataramani's book, I think you will be able to score more than what is the past market is there. The last question is, can the petitioner withdraw SLP, file a review in High Court, and can he file review after dismissal of SLP? Yes, this is again a debate which is going on. Now, finally, the answer is that if you file, if the Supreme Court had dismissed the SLP without reasons, the High Court order does not merge because the Supreme Court has not exercised the SLP power. You can go back and review. But if the Supreme Court has granted leave, and even if it is dismissed by one word, dismissed, once leave is appeal is, it becomes an appeal, the High Court order merges with the Supreme Court, and then you cannot thereafter go back to High Court. But if it is an SLP dismissal, generally speaking, then you can go to the High Court back to in the review jurisdiction.
So I'll just add to that, just look at two judgments. I don't remember the citations. Ajay Malviya and Sandhya Educational.
That's right.
Educational
Society. Sandhya Education Society.
Yeah, so there the court has given the distinction when you can withdraw and come back, and essentially the bottom line is this, that when you withdraw, you must seek permission of the court to come back against the judgment. Suppose you go in review, the final judgment in review. So if you have taken permission, then you can file an SLP. Otherwise, it is barred. So I would suggest that you look at those two cases.
Yes.
And as far as 142 extraordinary jurisdiction is concerned, it is exercised in several manners. One of the important cases on 142 would be Vishaka. You will find Justice Verma's exposition on how power under 142 can be exercised. And secondly, as Mr. Hansaria just mentioned, with regard to grant of divorce. Now, grant of divorce has been a little sticky proposition, because in the middle, Justice Kaju was of the view that the statute provides grounds for divorce, and that power in its discretion should not be exercised by the Supreme Court under 142. But I think we have overcome that, and the Supreme Court does exercise that power, because the operative words is to do substantial justice to the parties. So please remember that phrase.
Yes, complete justice between the parties. The Supreme Court has recently, Constitution Bench said the Supreme Court can invoke 142 power to grant irretrievable breakdown of marriage. You can grant divorce by exercising 142 powers.
Also, I see a question with regard to the length of answers.
Yes.
See, we are not very bothered about how long your answer is. It is like ingredients of a criminal offense. If ingredients A, B, C, D are there, you are sure to get good marks. So, like I explained when I opened my lecture, you have to give the provision. Number one, you can write this down. The first thing we want to know is whether you know under which provision the question is asked. The second is what is the substance of that provision. So basically break down Article 136 components and write it down. It's almost like you can write it down verbatim so that we know that you know what Article 136 says. Third thing that you need to know is a leading case in that. A leading case is probably, say, about 10% of your answer, but it is good for us to know that you have understood it from leading cases. But having said that, if you haven't put in a leading case, if you still have the content of the provision as well as the reasoning behind it, or like in curative, you have to tell us in what situation it can be invoked. If those parameters are covered, we are not bothered about the length of your answers. We need all the substantive aspects in your answer. Yes, we will be sharing this PPT soon.
Okay. And as Bhiwadi has said, as an examination evaluator, we want to know whether you have known or not, you have understood or not. Now, the length is not important, the contents are important, and try to refer to one or two leading cases on each subject. So, both of us told you what are the primary jurisdiction of the Supreme Court: original, appellate, advisory, transfer, curative, contempt. So, please have at least read on each subject 3, 4, 5 leading judgments. I think that will be sufficient for your purpose. And you don't have to write exact citation. Give name, nobody can read citation. Give name, that will be sufficient for a purpose of it.
Somebody has asked whether a synopsis should be given. We suggest you please don't give a synopsis because neither do we have the time while checking, nor do you have the time while writing. So convert your point-wise synopsis into your answer itself. And you don't have to answer the questions in serial order, but we will ask you to do that because it becomes easier for us to check.
Yes, that's right. You're right. And try to do it neatly, as neatly as possible, because again, because we are not used to reading, nor you are used to writing by hand nowadays. But still, when you are writing and we have to read, so make it readable and make it very neat and clean. That will help us to assess it, and then when it's helpful, you definitely score better.
Which is a lot of students are asking the question, the citation of the case you've mentioned, Justice Bharucha's case with regard to reference to a larger bench.
Yes. See, reference to a larger bench was, I'll just give you the judgment. One of the 1 minute. This is Bharucha judgment. That was, that is Pradeep Chandra Bharucha, 2002, 1 SCC, page 1, which is followed subsequently. You can note this is the leading judgment of Justice Bharucha, Pradeep Chandra Bharucha, 2002, 1 SCC, page 1.
Also, I see a question which asks whether e-filing procedure is important. Yes, please do go through e-filing procedure because that is what we are using now. And another point which we didn't cover, please check out the distinction between impediment and intervention.
Yes, that's very important. Yes.
Yeah, that's confusing, but it's an important, you can get some objective questions.
Yes, because they are very fine distinction, very important distinction. what is impleadment and what is intervention.
The landmark cases you can get from Mr. Venkataramani's book.
Yes. I think we can end by saying that if you read Venkataramani, you don't have to ask any more questions because it answers almost everything there. And it is updated version, because updated perhaps the last year, 2000.
Vijay, they are also asking a question which says, do we read 2013 rules or 2023 rules? I suggest they read both. 2023 rules are, I think, only the e-filing rules.
I don't think that 2013 rules are still hold the field. There may be only an amendment, Mr. Walia, isn't it? Mr. Walia, you can tell us.
Sir, there is no change of rule 2013.
Yes.
There is
Only
only
amendment
a,
is there.
yes, there is only a circular for e-filing. There is
Yeah, that's right. There are nothing like 2023 rules. There are only one rule, which is 2013 rules, Supreme Court rules. And I don't think there is any rules have been amended in 2023. There are certain circulars issued from time to time. That's all right. But then what we are looking for is the Supreme Court Constitution and the Supreme Court rules. That will be sufficient for your purposes presently.
should we wind up now?
I think we can wind up with.
In any case, if anybody has a question, we are there in court, so you can approach us.
Yeah, we are there in court, so you can catch hold of us. You will get a coffee and also your answer.
That's an attractive offer.
Thank you very much, sir. Thank you very much.
Thank you. Thank you. All the best, everyone. Do well. This may be your last physical theoretical examination which will be appearing.
Thank you.
Thank you, sir.
Okay, thank you.